like to reserve 5 minutes. May it please the court. Kevin DiMartino on behalf of the appellant, State of Ohio. The state is asking that this court reverse the trial court's decision granting Ms. Oberholtz's motion to suppress. Just briefly, the facts that are necessary for analysis of the issue before the court is that a male and a female officer responded to a domestic call for assistance. When they arrived at the scene, they found a male and a female arguing. At that time, the male and the female walked towards a house. That is a known prior complaint of drug activity at that house. The male headed towards the garage. The female stayed out front. The officers saw the male throw something they believed to be contraband. And at that point, the male officer who was staying with the male suspect told the female officer to pat down the female suspect. And the reason why he was requesting the pat down was because, one, there had been a domestic dispute, which the officers, based on their training and experience, know can get volatile. There was a known drug location, a complaint there previously. They believed that both the male and the female suspect showed signs of being under the influence of drugs, specifically methamphetamine. And because the male and the female who had been close together were now separated with the officers in between, there was concern for the safety of the officers. However, rather than do a Terry pat, the female officer, instead obtained consent from Ms. Oberholtz to pat her down and to go in her pockets. So the real issue in this case is the audio quality of the body camera. So essentially, when you listen to the audio and you play the tape, it is very, very difficult to hear Ms. Oberholtz say, yeah, when the officer says, do you mind if I pat you down, check you? She says, yes. And then she says, do you mind if I go in your pockets? And she says the word, yeah. But you do have to listen to the audio. I'd say, for me, it was probably a half a dozen times before I could push away all the overwhelming background noise. It's just very muffled and a lot of noise that's on there because there are people outside the house, and you obviously have two officers, the male and the female are also there, but you can hear it. So this state would argue that the finding of facts by the court are incorrect because the audio, when you listen to it, and you do have to listen to it a few times to be able to discern it, but it is there that the lady says yes. And equally as important is the fact that the female officer testified as to what happened. And she said, I said, do you have anything illegal on you? Is it okay if I check? And she said, an affirmative response. And then she said, is it okay if I go in your pockets? And she said, yes, it was consensual. So if you take the body cam out, the audio, the camera out completely, you have this officer's testimony, and there's no reason to doubt her credibility. The officer testifies as to what happened. But then the court takes this audio, which is not the best. They certainly don't use the best sound equipment on these body cams. They're not like recording studio quality audio. And uses the fact that it's difficult to hear the defendant's response as a way to just negate what the officer testified to.
Well, to that point, the question that I raised as I was reading the brief was just that the court could have simply credited the officer's testimony without any video or audio component in the case, and the fact that it did not, wasn't that implicit, an implicit questioning of the credibility of the officer.
I believe that would have to be the way to look at it, except there was nothing in the decision or nothing that the officer said that indicated that the court didn't find the officer credible, except obviously the finding that the court didn't hear what was on the tape. But I think that's a really, really dangerous precedent and contrary to public policy to take this position that if an audio recording on a body cam is muffled due to the fact that there's noise, and there's probably always noise. I mean, there's very few conditions that I've seen where it was, pristine quiet, like in a library, and they're asking, do you consent, and it's clear, to use that to negate the credibility of the officer. that to me just doesn't make any sense. And it puts these officers in a really difficult position when they're wearing the body cameras to protect themselves and to protect citizens, but they have no control over the quality of the audio. And this one in particular, when you do listen to it, and you do have to do it a number of times, I'm not gonna come before you and say when you play it, you hear crystal clear her say, yeah, you don't, you really do have to listen to it. But she does say it. And there's no reason for this judge to just negate all the other statements that were corroborated by this officer just because the audio quality is not pristine.
Well, it seems as if the judge analyzed this in the alternative and said, you know, even if we assume that that's what she said, from a legal perspective, it was, if you consider all of the surrounding circumstances, it was coerced consent.
Well, I think the way I read it, it seemed more like they were trying to say it was 2 questions at once, so it's not clear consent because she said, do you mind if I check and can I go in your pockets? But when you listen to the tape, there really is a pause there. First, the response is, you know, do you mind if I check? Can I look in your pockets? Yeah. So there are 2 questions with 2 separate answers. They're close in time, but there are 2 separate responses. And there's nothing on the video to support any type of coercion or any indication that Ms. Oberholtz did not consent. There just isn't. So I would ask that this court review the video and the audio, and I respectfully request that this court reverse the decision of the trial court and deny the motion to suppress and send it back for additional proceedings.
Thank you.
Thank you, Your Honor.
Thank you, Your Honors. May it please the court, I am Richard Kudichief. I am court-appointed counsel for General Oberholtz. Your Honors, this is a very important case today. The government comes here and says to you one thing. The trial court erred. It's mistaken. It messed up. Why? Well, because there's an argument amongst 2 individuals, and because there's an argument, well, there may be guns. And then domestic disputes, why they quickly escalate. And the residents, they were going to, well, it may have been a drug house, because we had a drug complaint there once, we don't know when. What surprise, it's a drug house complaint. But you know what, in this case, none of these things apply. So when we're looking at the facts, we got to figure, how do we get from a domestic disturbance all of a sudden to a drug investigation? And that's of extraordinary and critical importance here. And we'll get to that here as I continue. The prosecutor basically argues that Janelle consented to a search. That's the whole predicate here. But there's nothing, no behavior by the police officers that demonstrates in this. So why bother with this case? Here we have a little case, you know, Janelle, I mean, she had drugs. After all, I mean, she had drugs. The importance of this case, the critical nature of this case that this court needs to take a look at is the 4th Amendment of the United States Constitution. Now, Judge Parker was the trier of fact, and you know very well the standard on a matter of this nature. He's in the best position to resolve factual questions. That's the law. He's the ability that can evaluate the witness. He's the person that can look at what is going on and ask questions. And this court, you must accept the findings of the trial court, the factual findings, if it's supported by competent, credible evidence. So we have the testimony of the police officers, and we have a videotape. The audio quality, that's all part of the factual resolution. The problem is the government, the state of Ohio cannot prove, they cannot carry their burden below to demonstrate this motion to suppress in their favor. Having to accept the the facts of the trier as true, then you have to figure out, well, does that then satisfy the legal standard, and that legal standard is that of the Fourth Amendment. So pictures don't lie. Take a look at that video. I heard it many a time as well. It's an issue of, if you see a couple walking down the street arguing, does this then now commence the opportunity for police to have a field investigation? Becky and I, my wife Becky and I, we were in New York City here a couple weeks ago, becoming grandparents. So our emotions were high. We're walking down the street, we were in Greenwich Village hanging out, waiting to go back to the hospital, and we had some tensions, the two of us. Now, it's not typical for us to argue, but we got into an argument. I was probably wrong, I would confess. But that was an opportunity then for the police to come on a disturbance. Are they going to come to me and then say, hey, by the way, do you have any drugs on you? Here you are by New York University, and I know there's drugs there by Washington Square Park because I smell marijuana. No big deal, but that was the fact and reality. So, can people like us now be subject to the same circumstances as Janelle Oberholtz? That's what this case is all about. So let's take a look at the facts here. Domestic disturbance, these are the facts. Police see Janelle and Aaron arguing, walking down the street, but they're yelling at each other. I don't even know about the arguing. There's no physical fighting. The couple turns into this driveway. Aaron goes to the back, and Janelle stays down here. And you hear the first officer say, go ahead, do a pat down now on Janelle, on the girl, on the woman. Now remember, the state of Ohio stipulated at suppression hearing, this is not a Terry pat down, so that's not involved. But you have some confliction in the testimony. Officer Tassone testified that, and by the way, those remarks were even made before the police officer observes Aaron supposedly throw something down on the ground. He still says, go pat down Aaron, pat down Janelle. And then the other critical component here is Officer Tassone asked Janelle, hey, are you okay? There's some conversation. And Janelle says, yes, I'm okay. We were just arguing about some texting. So it's not a Terry pat down, but now all of a sudden it's a pat down for safety. So if you take a look at the video and watching what Janelle is wearing, and that's just how Janelle's style is, she always wears, she's a little girl, skin tight stuff. How you would hide a gun in there would be beyond me, or a knife, but whatever. It's okay to go talk to these folks. There's nothing wrong with a police officer coming up to me and chatting. I can tell the officer no sir, or if I was rude I could swear at him. But in certain circumstances you do. So let's say the stop was appropriate here. I'll give that for the moment here. The officer then starts, there's this conversation, so I urge you, if you look at the video and talk about the behavior of this police officer, this interaction between Officer Tassone and Janelle is so seamless. How do you get to the consent? Even if, let's just assume for 1 second for argument, Janelle said, yes, certainly, the police officers, and can I do this and can I do that? And she says yes. Where is the behavior stopping where there's a conversation? Can I search you, ma'am? It's so seamless, it's almost impossible to logistically define a legitimate consent regardless of what words were murmured. Now remember, keep in mind, the trial court heard it all, heard the witness, looked at the video, the factual findings. So if you take a look at that and the findings by the court, the state of Ohio cannot achieve their burden of proof persuasion to overturn the factual findings, let alone to produce sufficient facts at the hearing. So here, the government has to demonstrate for you sufficient persuasion that somehow the trial court erred in its fact finding, and they cannot do that. The record does not support that. The audio does not support that. So you must accept the fact finding by the trial court. So let's get back to me. Your Honors, if the New York Police Department can stop and frisk me, just a regular person, not a young potential druggie at a drug house, that's what this case is all about. That's why it's so important. What you say here, this ruling is critical to the Fourth Amendment, to the United States Constitution. That's how important this case is. Now,
Do we need to analyze this in your opinion? Do we need to analyze this in terms of consent for each one of these events, the stop, the can I frisk you, can I go in your pockets? Or does just one of those answer the question that's before the court?
no, Your Honor, I think you can separately identify each of the components. I think that's fair, but you must look at the totality of the circumstances to come to a conclusion as to whether consent is given. So if you look at the behavior, you look at the body, and if you look at the seamless approach, there is no components. And that's part of the problem that becomes of critical proportion here. It's very difficult to hear verbal so that you can't conclusively decide that there's a verbal consent. The court finds that, but things are going so fast and it's so seamless, you cannot, under the totality of the circumstances, say that she consented.
Well, and the reason why I asked that question is even though there is language that the state said this wasn't a Terry stop and that was a consensual search, the trial court's entry has findings like the court finds that the search was not conducted for officer safety. So I'm trying to understand where the true disagreement is, what the true part of the law is that this court needs to analyze to enable us to reach a conclusion, because there's a whole lot else in here other than just the officer did or did not have voluntary consent to go into the pockets.
You're right, Your Honor, and that's a strong point. The point of, we're always going to say officer safety, especially in this day and age, especially. But where does the line stop? Where does the line cross where you can always say, well, we're going to pat someone down for officer safety, just like me in New York City in Greenwich Village. Why not? I could have a gun, so we're going to pat this guy down, and all of a sudden we're going to find some drugs, because I had some Tylenol with codeine on me because I was having some severe pain issues that I had put into my, daily planner thing that was out of my prescription bottle. I mean, so before you know it, I'm going to be charged with having drugs on a pat down for officer safety. You must delineate officer safety. The facts in this case don't provide for it, Your Honor. That's why the court found that. That's why you have to accept that fact finding. There was no cause for officer safety. So
I have a question regarding the facts that was not clear from either the court's judgment entry or the briefs. Explain to us what happened when the officer approached your client and began the search, and when the handcuffs were put on her, and the time frame when the search went from the outside of her clothing to under her bra where the syringe was found. It was very unclear as to whether or not the officer was asking your client to lift her bra under her shirt, and if so, were her hands handcuffed in front of her or behind her?
yes, Your Honor, let me start and answer that question by my next topic here. So now we're taking a domestic violence domestic disturbance call, and now all of a sudden we're moving into detention for field investigation for drugs. So we start out with domestic, now we're moving into drugs. That's how the seamless approach starts. So when the police officers when the one officer says, go ahead and pat her down, then we get the the starting point of this investigation by the officer. We have her doing the various things, and if you watch that, the seamless approach is she progresses through this. So the starting point is, can I reach into your pocket? She reaches into her pocket. Then she does the next step. And that's where you have to really look at the video if you're going to overturn the factual finding, because that's where the issue. Did she say, yes, you can go into my pockets, or did she not? So the police officer then starts with the pockets, then does the handcuffing, then says, look, you gotta do this, this, and this with your bra. You know, she didn't do her bra right. Honestly, I don't remember precisely about the cuffing component, but it was definitely after she was told, instructed to do her bra. Then she, at that point, I believe she was cuffed, and that is when the police officer started. And again, look at Janelle. Janelle's just such a little girl there. I mean, and that's what's so critical here. That is what is so critical in this case. That's
You're
why.
down to 1 minute.
What's that?
You're down to 1 minute remaining.
Judge, I want, judges, your honors, I want to conclude. The importance of this, a warrantless search, how you define this case is of critical importance. Why is this case important? It is important to protect the United States Constitution of America. Stop and frisk is not the trend. You cannot set, if you overrule this decision, you're going to enable and provide for stop and frisk. It's a wrong thing. A warrantless search in this instance is constitutionally invalid. The state could not demonstrate a valid search exception here. You can't, you have to look at Robinette. I think it's important. This case is important because the police went beyond Fourth Amendment protection. You gotta affirm this case to protect the Fourth Amendment, the United States Constitution. Thank you for hearing me. If you have any questions, if not, I'm done with my argument.
Thank you very much.
Thank you, Your Honors.
Mr. Martino, you have 5 minutes remaining.
Just briefly, the state first argues that the court's findings of facts were not supported by competent, credible evidence based on the audio tape. And then 2, that the legal conclusion was not correct because it is not appropriate to disregard the testimony of an officer based on the poor quality of the audio tape. This case really just comes down to this one issue, in my opinion, which is the issue of consent. And with the the issues that are going on in this state and all across the country with officers and body cameras and whether or not they're going to wear them and what the effect is if there is audio or video, I think it is very important for this court to set forth clearly what the rules are. If there is an audio and video that is recorded on a body cam of an officer and for whatever reason the audio isn't as clear as we wish it would be or the video isn't as clear as we wish it would be, does that per se render the officer's testimony, which is otherwise corroborated by the evidence, to somehow lack credibility and be the basis for a suppression? And the state would argue that it is not, and we would ask that this court reverse the decision of the trial court.
Thank you.
Thank you very much.
Thank you both for your presentations. The court will take matter under advisement, will issue a written opinion, and it will be sent to both sides, and we can certainly check the Supreme Court website.
Thank you, Your Honors, for your time and attention.